Hey, everybody, welcome to today's episode of the What Worked For You show. A little bit of a different spin today. Our business owner guest today, necessarily a real estate person, but not at all, not necessarily in retail or this, but he's touched probably every industry out there or close to it. He works with intellectual property law and he's owned his firm helping people with this particular subject known as intellectual property. He's worked on and completed over 700 U.S. patents. He's been a patent examiner for the USPTO. He has his own law office and he's worked with brands that you've heard of, Amazon, Alibaba, to name a couple. So a broad range of experience working on a very niche field that a lot of times you don't hear much about, but it's very important when you go down some of these roads and you really do bring something unique to the market or special, and you want to make sure that someone doesn't take it out from under you. So with that, Austin Bonderer, thank you for coming on the show today. How are you?
Pretty good. Thank you for having me, Frank.
Wonderful. So this is an area I don't know a lot about, so we're going to just see what happens here. And so my first question was, you've been listed on over 700 patents, which I'm sitting there thinking that, I don't know if that's a lot, but it sounds like a lot, especially when I think of how the legal process is not a fast process. And it sounds like a lot of attorneys that work in your field never get to a number like that. What does an accomplishment like that mean to you at this stage in the game, as long as you've done it?
Well, just let me reiterate. Part of that was I'm basically listed on over 700 issued U.S. patents. Part of
Okay.
that was his time as a U.S. patent examiner. So I was at the patent office approving or disapproving applications. And, the reason why I put that number out there is like one of the things I feel like I've seen almost anything you can see in patent prosecution. And then on the other side, when I became an attorney, I worked with a large fortune. I worked for Foxconn, so we basically had a very active intellectual property department, and I oversaw and dictated the patent prosecution on many patents or patent applications that later became patents, and that's how I was listed on a bunch of issued U.S. patents then. And then obviously, when I've gone into my own solo practice, I've carried on that tradition of hopefully getting people issued U.S. patents, which then, bear my name. So,
So you use the phrase in there that, and again, and part of my ignorance that I haven't heard, but you used it twice, patent prosecution. So in today's world, the average person, you hear the word prosecution, it's probably on the news media and it's probably associated with some kind of global or domestic drama that captures headlines. But some people have dealt with prosecution, right? Because they maybe have had something horrible happen closer to home.
right.
When I think of a patent, I'm like, prosecution with like, tell us what does that mean? Because I was like, wait, I thought it was just, I just want to protect my stuff. What, like, tell us more.
Well, but of course, you're right. Patents have its own lexicon and they use interesting words. So basically, when you deal with patent attorneys or people dealing in IP, especially with patents, you generally either fall as an attorney as a patent prosecution attorney, which means you are the guy writing the term paper, you are the guy, person arguing with the patent office, and they're the ones who get you your patents. Then you have patent litigation. I don't do that. Those are the guys who go into to the court. They're the cool ones. They're the flashy ones. They're trying to get people to believe what they're saying. I'm more, the type of person. So just let's put it this way. Sometimes people ask me, what do I really do for a living? And I just say, I write term papers for other people. So basically, I'm sitting in a dark room. I mean, it's not dark, but you know what I mean. I'm just typing on a computer, writing out a term paper, getting it approved by the client, and then arguing with the patent office about it once they get to look at it. And then hopefully we arrive at a patentable invention that issues.
So there's this idea then of the patent prosecution. It's more like an application and then basically going to the patent office and effectively convincing them, yes, we're special enough, unique enough, whatever the right term is, that you should give us this.
Exactly.
Okay, okay. See, I learned something. I love
Well,
it.
maybe we just wanted to have a cooler name, like we do patent prosecution. Like
Right.
sounds a
Well,
little
I mean,
better.
it's an interesting choice of words. Because generally, when you hear the word prosecution, you think of a negative connotation. But in this scenario, you're basically just trying to get something to protect your stuff. That's a positive, right?
Right. Well, who knows? You know what? If we went back and looked at the original meaning of the word prosecution, it probably just meant something moving it along or this or that. And then it turned into persecution or very similar to,
That's true. So maybe we need to go back to the ancient Latin and see what's going on there.
exactly.
So you talked about you worked at the USPTO first. Like
Yeah.
what did you do there and how does that differ from running your firm? Was it like two different roles or were you doing the same thing and you went out on your own? Like,
It's the other side of it. I mean, honestly, when people ask me what they should do if they're coming out of engineering school and they're interested in, possibly pursuing this career, I'm like, go work at the patent office. It's some of the best training you will ever have. One, they will train you. Two, you will see so many different cases that you get exposed to a lot of issues that come up. And then after, 4 years, I think it is, or 5 years, they basically make you take a test, which then qualifies you if you ever leave to be a qualified patent agent. Or if you happen to be a lawyer and have passed a bar, you will be a qualified patent attorney.
so, so effectively what I'm hearing is it's like 5 years of paid training.
Yes. And the other part is I don't know if it's still true, but it had the highest civil pay scale of any department in the US government, to my understanding, at the time. I don't know what it is now, but it's a very high paying job. They also have it where, eventually if you get, I don't know if you have to work there for a year in DC area and then you can move anywhere you want, but you can basically take that DC salary and move to your, small hometown. And then trust me, you are doing pretty well.
Wow. Very
Yeah.
fascinating.
I honestly
So,
say, I tell people like, if they had that program when I left, I would have never left.
wow. Wow.
Yeah.
Very interesting. So, you talked about there was a lot of different industries. And so, in this role at the USPTO, you're seeing everything come at you. I mean, I guess you saw everything from like the Amazons in the world to the smallest mom and pop idea to everything in between, I would think.
Kind of. They do try to specialize you. I was actually lucky enough that I did three different areas. My first area was in, valves and fluid mechanics. The second area I was in was during the dot-com boom or towards the tail end of it, doing business method patents. And then I moved to the medical field. But generally, what happens is you become an expert in your very small area niche because they want you to become more efficient. So if they had us searching everything and if something that came across our desk was just always, could be anything, it would take more time. But what happens is these people spend 20, 30 years inside a very specific art. And when we say art, we mean area of technology. And I can tell you, like, I remember going to the experts when I was a young examiner and saying, hey, I'm having a hard time finding this. And this was back when we would go through the shoes. It was just these stacks of drawers with patents in them. And they would go in and be like, it's in between those two boxes. And that's just how well they knew everything. Obviously, that has changed since they moved to an electronic search system, but these people knew that art inside and out because they had been practicing it every day, for 20 years.
Gotcha. And when you were saying boxes, my first thought was the card catalog.
Yeah.
And then,
I mean,
but then my next thought was like, Going back to like the Indiana Jones movie where they had the warehouse scene and you have all this stuff. And well, and in more recent times, we heard about how the government, I guess it was the Social Security Office or something like that, whatever it was, that they were using some antiquated systems or
It was the retirement system, and it had to go
that's
to
what it
a
was.
salt
Yes.
vault in West Virginia in paper form. I think that's what it was, right?
Yes. And it's amazing to think, but that would still be happening at the government level. But the reality is, there still are a number of businesses that operate that way. You know, everything is not fully electronic everywhere, so we can't go too crazy with that. It's going to take some more time. But
Yeah.
so you were working in some niche areas, and so it sounds like there would have been a lot of people there because there's a lot of niches out there.
Oh, yes. I mean, I always tell my clients that while there's one patent office, there's almost, I would say 9,000. There's actually 9,000 of them because
Wow.
every patent examiner is their own little patent office. And then you deal with different, personalities, different way they look at things. It's all about the paradigm that they have. Sometimes you'll go into a patent application thinking this might be your weak spot, and then they come back and you're like, oh, that's what you're that's what you're thinking. And and it also helps because I write my application, I write my claims, and it's good to have someone almost argue with you over it, and it makes you a better patent attorney, or at least your claims better, because they may see an angle that you did not see. So when you're trying to write a very specific claim, they might say, hey, that word kind of includes a lot of other things that you are not trying to invoke here.
Mm. So you get negotiation skills out of the deal.
Oh, it is 100% a negotiation. It is.
Wow, wow, wow. And I guess it made sense because your client is, or the business or whoever is coming to this patent office and saying, this is why this idea, thing, whatever is unique. And I guess when you were there, when someone comes into you and says, this is unique, I would imagine, and again, I don't know, but it seems like you would have to not only cross check your own database, but it's almost like you'd have to cross check a much larger, almost like you have to cross check everything because, well, maybe there's some in another field that's super close and there could be like some misinterpretation and, oh, well, they're stealing our idea, but no, they're really just different enough. Like, was that a thing? It seems like it would be.
I mean, yeah. I mean, here's the examiners are limited by time and scope. They're generally searching U.S. databases, even though a disclosure in Korea would count as prior art, but we can't find it. So we're generally just dealing when we're dealing with U.S. disclosures and U.S. patents. Um, and speaking on what you were saying, one of the areas I worked in was kind of like bone screws, just simplify it. So these surgeons would come up with new screw types to, attach to bones and stuff. I would go search in the, hardware art. And I can't tell you how many times I got back. They would be like, what are you using? This is not a bone screw. I'm like, but it's a screw. Just because you're drilling into bone or trying to secure something to bone doesn't mean the concepts of, the specialized screw with different pitches and this and that hasn't been known. And a lot of times you'd find stuff from the 1900s, 1800s, those kind of things. And let me tell you, it would set people off, but that's the way it works.
Wow. So 1800s, we're going back a way. So this office has been in place for a long time then, it sounds like.
Oh, it's in the Constitution.
Okay.
The
Okay.
man back there, actually, Thomas Jefferson, he was the first commissioner of patents,
Okay.
and he issued, I think, the first U.S. Patent.
Wow. So all the way back to the beginning.
Right, and it's in the Constitution. It says inventors shall have, for a limited amount of time, exclusive rights to their inventions and creations, something along those lines.
Just another reason why our founding fathers were brilliant.
Yes.
They were, they don't get enough credit. Those were some smart cookies back then. So, wow. Well, You've protected brands across global platforms. Mentioned like Amazon, Alibaba. You were just talking about domestic, and now it's like, oh, now there's an international piece of this. How do you help entrepreneurs today feel confident that their innovations are truly safeguarded?
Okay. I just want to clarify one thing. I Amazon, Alibaba were not my clients. I have protected my clients, from products on those platforms
Right.
or, worked, inside the Amazon processes to try to, with patent infringement and this kind of stuff.
Hmm.
So, back to your question, I'm sorry. When you have a patent, back to your question, like how do we know that we're secure? When you have a patent, even if it's issued, it can still eventually be rendered invalid because someone might find a piece of prior art that, like I said, in Korea that we didn't know about. And they may be able to bring it over here, go to court and validate your patent or restart proceedings at the USPTO. So when we're working on this, it's always a risk. Now, when we're talking about Alibaba and Amazon, one of the big things that we're talking about is brand identity. I mean, even with your real estate stuff, if you're crossing state lines, you want to have, excuse me, a registered trademark so that you can, hey, we're in this real estate space. You can't have a name or logo that's similar to ours. Anything that's likely to cause confusion, we're able to make you stop. Now, understand there's common law trademark rights, and then there's the registration federal. The federal registration just gives you a lot more protection and turns it into nationwide protection.
Mm.
If you rely on common law, you can be limited to geographic scope. So say that somebody's working in LA and somebody's working in New York. If they have the same name and they don't know each other, then you might have issues down the road. But say that the person in LA started, and then got their federally registered trademark soon, they could possibly prevent the other person from starting a business with the same name because they have federal registration.
So you did have two business, and I have seen that before. I mean, it's rare, but I have seen an instance where I was like, I've seen that business name, but it's in another state.
Right.
So that can happen if neither of them has registered their name federally, is what my understanding.
Correct. And then, also one of the requirement, for some reason, this is the last one. I don't get it. Federal government, it seems like it used to be they couldn't regulate interstate commerce or intrastate commerce, sorry, commerce inside the state. But, through rulings and laws, they've been able to pass laws that if you did something inside your state, you can still break federal law, even if it had nothing to do with interstate commerce. But for some reason, they've decided when it comes to federal registration of trademarks, you still need to have interstate commerce. So, in other words, you have to have clients from out of state, you need to have offices out of state, you need to have some kind of presence that cross state lines. Now, this is getting a little blurry because of the internet, right? So, you might be advertising, and two, like you take East Coast, like Connecticut, New York, this kind of stuff. You have a business in Connecticut. I mean, it's so close to like three different states. You could argue that. Now, if you're in the middle of Texas, that's hard. But all that being said, this is where it's a little wishy-washy. All that being said, but you still need to show some sort of interstate commerce before you can get a federal registration. Now, what I always tell people, and this is just, everyone should do this no matter what. Until they have a federal registration or whatever, if they have a name that they want to protect as a trademark, they should use that little TM that they see on other products. And that literally lets everyone know that you are claiming a trademark for your business. Doesn't have to be interstate. You can have one location and one customer. No one cares. Just as long as you put that TM on there, that is putting everyone on notice that you are claiming this as a trademark.
Mm. So you would even recommend that, like, obviously larger companies makes perfect sense, but even like a small company.
I mean, half the, when I get the calls for people with trademarks, they got letter from somebody, they're a small company. another small company, but they're saying, hey, I have this registration, or you're causing confusion within the area. So the whole
Mm,
point of trademarks, let's just go back a little bit. The whole point of a trademark is not to protect the owner of the trademark. It's to protect the public. Because at the end of the day, we have to easily identify the source of goods that we're going to buy and spend money on. And we do that with trademarks.
mm,
So the whole point is that if a brand or product becomes associated with a name, someone can't cause a likelihood of confusion by selling something similar, with a similar name or a similar logo. So the idea is that you're just supposed to move commerce along. So when I see the McDonald's symbol, I know what I'm getting no matter where I'm going, right? I don't know. You're older like me. You might remember Coming to America, right? McDowell's was the restaurant that the guy owned, and McDonald's was always trying to tell him, you can't do this. But because it was confusing customers.
mm. So then, as a small entrepreneur, you're out there, you're selling a product, service, whatever it is you're selling. There's value to going ahead and getting the trademark.
Well, it's just so simple. I mean, you don't even have to go out get the registration if you want. It gives you a lot more rights, but the bare minimum, put the TM on there.
Yeah.
It's free. There's no registration, there's no nothing. You're just letting everyone know. So if someone moves into your town and has a name very similar and starts, say you have a restaurant, put a TM on it. If someone moves in close, they have a similar name, you can say, hey, I've started here, clearly identified this as a trademark. You need to stop. And additionally, even if you didn't have the trademark or the little TM on there, you still have rights to say, hey, you are causing confusion between the people that I have identified, or I mean, the people that I have built a brand with. You're causing confusion. So don't do that. And, that's kind of how it would work in the common law setting.
Wow. And you had mentioned, so going back just a little bit, you also mentioned that you could do everything. My interpretation is you could do everything right and think you're protected, but then there's the risk that something come up and almost like, if I understood it correctly, like someone international could say, wait a second, because you were talking about, you're researching domestic, but an international entity could come in and say, wait a second, we've got a conflict here.
Well, that would be on patents.
Okay.
Trademarks but your trademark can get canceled. I mean, they could have not found somebody that had been using the name before you have in the area that you've been using it. And they could challenge your trademark and say, actually, we have priority to this name and the use. Therefore, we're going to try to challenge your trademark. Once it's issued, it's not the end all be all. Now, for patents, what I tell clients is like, look, we'll do a prior art search. And for my firm, prior art search generally costs a client between $1,100 and $1,600 out the door. But understand, we hire a search firm. These people are experienced, very good at what they do it every day. Their skill is honed, but it's an art, not a science. Two, they have a limited amount of time to do it and then limited amount of databases to go through it. So if you end up getting a patent and someone starts infringing your patent, say it's a big company, we spent 1,100, 1,600, they're going to spend 10,000 to 100,000 searching all over the world for art to try to invalidate your patent.
Wow.
Yep. So I remember one time when I was a younger attorney, I did work a little bit in litigation, and it was Netflix versus Blockbuster. I mean, that's how old it was, right? But
I
I can
remember.
just tell you, the searching, concerning that patent was extensive. And that's all I can say. It was just very extensive because think about it. These guys are going after each other for millions of dollars. What's $100,000 plus? I don't know how much they spent. I'm just saying, what's $100,000 on a prior art search that might find you the silver bullet where you're just like, hey, I didn't infringe anything. This patent's invalid.
Wow. Wow. Very fascinating. Very fascinating. And we've heard about some of these battles. In the public space, we've certainly heard of some of these things over the years, and very fascinating. Well, let's step back for a moment. What did you do before you got into this world of patent? And did you start your career here? Or did you do something prior and jump into it?
It's probably one of those stories. So in engineering school, we had a thesis project, and I had this idea for a very long time because when I was younger, my dad's house almost burnt down in Mississippi. So that summer, I spent in the attic helping him wire a smoke detection system in his home. It was miserable. I mean, there's nothing like being in an attic in July in Mississippi. It's just like it's
Yeah, I would
yeah.
agree.
All right. So I've never been in hell, but I've been there. So and this is when the wireless doorbells first started coming out. So basically for my project, put together a smoke alarm and those doorbells. And basically the idea was is that you would have two forms of triggering a smoke alarm. Basically, it would be a wireless signal from another smoke alarm that sensed a fire. So if it sensed a fire, it would send a wireless signal and an audio signal. But then it would relay through your home. And eventually this became a product. I know for a fact that at least I believe for a fact that I beat these people actually to the market. But I was a college kid. This is my thesis. I presented it. You can still find it at the library at the University of Virginia.
Hmm.
But I didn't have any money. I didn't know what I was doing. I wrote a provisional patent. I've read it since. It was horrible. I would never want anyone to see this thing. Uh, so that being said, that kind of got me interested in it. So I worked at the University of Virginia's intern there, excuse me, technology transfer office, and I was like, I want to live on a college campus. This is like they're wonderful places, right? And they're like, no, you need to go out and get some real experience before you can come here. So the patent office was actually hiring at the time, and they offered me a job. So I became a patent examiner right out of college. And then I went to law school at night. That's how I became an attorney. And then so be it.
Okay. So it started in the attic in Mississippi.
That's right.
It's always a fascinating point of beginning for so many stories, but it made sense, right? And then, of course, we all know what technology is doing today, even in the smoke alarm world. I jokingly made a social media post a few weeks ago about a smoke detector not working, and they were talking about, well, if you freshly paint a house, it might cause it to malfunction. I'm like, so it's a paint detector now? It was a very bizarre conversation. But anyway, so what he said, I was like, yeah, anyway. So, wow. So there was a fascination with it. You got involved. You did the law school thing. And so you went straight into the USPTO from there.
Yes, it was my first job. I went to school for engineering and didn't spend a single day doing it. So,
There you go. Well, we can all relate to that. A lot of us can at least. Very common story for sure. What was one thing you learned at US? And obviously you learned a ton at USPTO, 5 years of basically training. But what is maybe the one thing you got out of that experience that really shaped you in a way that, it drives your practice today?
um, it's really personal with the examiners. I mean, you know what the law is, and it should just be cut and dry and this and that. But you're dealing with this thing called the obviousness standard. What's obvious to you is not obvious to me, and that's where a bunch of arguments can come in. And you know, I think it's just same in any business. Just pick up the phone and call somebody. You can get so much further. You can understand, you hear it in their voice, you can see what they're saying. A lot of times they want to help you. And I feel this way in almost all business situations. Just call. And I know it's becoming less and less prevalent in the younger generation. They want to text. They don't want to, they don't want to have those conversations. But there really is nothing better than getting on a phone and talking to somebody about an issue you have and trying to work it out.
Yeah, and now with AI, of course, you are seeing where, well, okay, I don't even have to touch. We'll let AI do it, all the thinking for me and programming your AI to think like you. And for sure, there's value in all that. There's some powerful things you can do, but it's hard to imagine a day where it'll truly replace that human to human interaction. It's just not sure
I,
they can.
I mean, I don't know if it'll replace it, but it may substitute for it. I just, I feel like too many people
Sure.
don't like that, thing. And then, my issue with AI is my concern is that you have the poisoning factor. So I was in the AI conference the other day, and the guy said, say you're doing a plumbing, right? And you take 100 pictures, and 99 of them are proper plumbing. The one picture is not. You've poisoned the data set. And the issue is going to be is, we might be the last generation of properly trained patent attorneys. Who's going to spot the poisoned output? And if no one's able to keep training, we're not going to be able to shepherd AI into being correct. And we're just going to have this, little bit of poison that's still left in there, and it could cause a lot of problems.
So AI could effectively become no different than your average computer, garbage in, garbage out.
Correct. Correct. And without someone to know what they're doing, you're not going to be able to, judge it.
It's interesting. Recently, I've told people, and I use AI. I think most business owners do to some degree because it is helpful. But I've also learned that if you present an issue to AI, it'll like start taking sides with you. Well, I think such and such, da da da. What do you think? Well, you're right. And then all of a sudden, you don't have an objective computer. You have a computer that now is taking sides. No, no, no. I need to, it's like you have to tell it to be objective. Is that something that you've seen happening in your world where people are using AI to formulate an argument, but really it's just accentuating existing thoughts and bias rather than being a truly objective tool?
No, I may be a troglodyte. I do use AI for little things and here and there, but I don't use it for my patent work. And it's just, again, I can understand what you're saying, but I personally don't use it. I know people who do. I have two issues with it. One, it's an AI learning, it's called LLM, language learning model, right? They're learning from you. So if I'm telling it, you know, things that are supposed to be confidential, have I disclosed confidential information to the world's largest database? That's my concern. I have inventors that are like, yeah, I told it my idea and I put it, I'm like, well, maybe you just publicly disclosed it. And until the Supreme Court rules on it, I'm not touching it in that context.
Mm.
So that's my concern with it. And then, the other part, I've asked it some pretty poignant questions about things that I know about, and it's been wrong. I mean, just blatantly wrong. And then when you tell it's wrong, it's like, oh yeah, you're right. It's like, yeah,
Yes, I have seen that.
yeah. So, you know,
Yes.
I wonder if I told it, I haven't tried this one. I wonder if I told it it was wrong for something that I knew it was right, what it would do.
That's interesting. I know there have been times where I've used it and I literally had to tell it, please give me the sources for your answer. But you cannot use public mainstream media. You cannot use opinion pages. You cannot use Wikipedia. And the system would be like, oh, you want like real stuff, like Supreme Court levels. Yes, that, like the real thing.
Yeah.
So, no, I hear you. I hear you on that. So you've worked in some of the technical fields you mentioned earlier. You talked about medical, for example. You've been in nanotech, e-commerce, some of these things. Which of these areas, like, does any of these areas stretch you more than the others as far as enhancing your skills and ability to serve your clients? Like, are some fields harder than others, or is it all kind of the same?
Well, here's the thing. Like, if I don't feel comfortable with the subject matter, I won't touch it. So if it's like heavy duty chemistry, or, when you're talking about covalent bonds or, things attaching this way and blah, 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 or pharmaceuticals, I just stay out of it. But in reality, all the other things, it's just kind of the law applied to technical knowledge. And you just have to know what you're working on and then apply the law to it. And, I've been doing this for so long, honestly, they start to become the arguments. There's only so much law in this, right? I want to say it's like,
Yeah.
you can argue the technical part, the law part, or both. What's the old one? If you have the facts, argue the facts. If you have the law, argue the law. If you have neither, bang the table. Like that's
Fair.
I mean, that's kind of where we are with this. So, I mean, it's either highly technical and you got a good argument why this doesn't work. Well, the combination or whatever the examiner's doing. But, sometimes they're right. And sometimes you just go back to your client like, look, they kind of have us dead to rights. We'll just be wasting money if we move forward here.
Interesting. So what was it that led you? You did the PTO thing, USPTO, and then you went to a firm, then you went out on your own. Tell us about that progression of how one led to the other, led to the other. What was that like?
Actually, so the main reason why I went to law school, like I said, well, I don't know if I said, but I really enjoyed being a patent examiner. It was a great job. I mean, it's a government job. You're secure. It's as long as you get your work done and you're on top of it. It's a great job to have. Then they had it where you could live anywhere you want. They didn't have that when
Right.
I was there. I would have stayed. But my issue was I eventually wanted a family and I didn't want to have to live in Washington, D.C. my whole.
Mm,
So the only way to get out of that was go to law school and become a patent attorney. Well, at least for
okay.
me. Some people just become patent agents, which is totally fine. It's a patent agent is able to do anything I can do before the patent office, but they can't do any other legal work. So, but for me, that's kind of what it was. So I just kind of wanted to leave DC. I grew up in a smaller town, Mississippi and stuff like that. So I didn't want to raise a child in Washington, D.C. However, I ended up raising him in Orange County, California. So it really wasn't that big of a difference. But, I should have just stayed there.
Fair.
But, so that's basically what pushed me out of the office.
Gotcha. So you left and you went to work with Foxconn, I believe you said it was.
Yeah. So, no, well, I didn't initially go with him. I had my own practice. Then I moved to California and then I
Okay.
ended up working with them, which turned out to be, I mean, I never thought I was going to be able to travel the world as a patent attorney. Right. So I got to
Wow.
go to China many times, visit, got to go to Beijing, got to go. So I would present sometimes at this Tsinghua University, which is my understanding, like it always competes for their number one, number two, working at a nano tech center cooperation between Foxconn and the university. And it was some of the coolest things I've ever seen. I can't get into it, but there are some things in there. One of the patents I worked on and got it through was it was this wire mesh, super fine, transparent. You could put it on clothes, flexible, but it was a speaker. So you
Mm.
could turn clothes into speakers, you could turn flags into speakers, you could do any of this stuff. So it was a pretty interesting, science, but it would be like it's cost prohibitive to do it mass production at the time. They may be working on it now. I'm not sure.
Well, they got cameras and glasses now, so it doesn't sound as far-fetched these days. I've seen that was like this, someone's wearing glasses, you're like, why are you blinking at me? Right.
Well, I remember growing up, I was like, "Where's the phone in my shoe?" Like, wasn't that Get Smart or something like that?
Yes, yes. Now they're sticking tech in everything, which has its value, right? In some ways, right? Maybe not. So
Yeah.
we'll see how. It's going to be very interesting to see how the world evolves, as things come down the road. So, what about for the entrepreneurs? Like a lot of entrepreneurs, this idea of protecting IP, I mean, it can feel kind of intimidating. Like, I know if I went into it, I'd be like, what are we really doing? Like, because you're kind of diving into something that's, as you mentioned, it's niche, so it's not something we generally spend much time thinking about. But how do you help people with their fears? Because I would imagine they come to you and they're like, right, like we fear what we don't know sometimes. And now we're dealing with the government, so the bill could be kind of large, and we don't even know what we're fearing, and it's expensive, and right, you need to turn it into this big thing when maybe it's not, as you were mentioning earlier with the trademarks. How do you help entrepreneurs navigate that?
Well, I mean, I look at both of them as kind of forms of insurance. So if you get a patent, it helps insure your effort and the time and money that you spend on trying to develop this product. The same thing if you're able to secure a trade name through the trademark office, that you're not going to push this product, build all this goodwill, and then have someone generally come up to you and say, hey, you got to change your name. Because that happens to my clients all the time. They'll call me up and say, hey, I got a cease and desist letter. I've been operating in this name for 5 or 6 years. And I'm like, you're going to have to change your name.
Mm,
So, and then when it comes to patents, they are expensive. It's not cheap. It's a lot of work on a patent attorney side. It only protects you in the United States. If you want to, go overseas, it's going to cost more. But again, if you're able to get the patent, you're able to, protect your time and investment. But there's still no guarantee. I mean, the issue with patents is they have to be timely. Like you need to file it, I tell people you need to file it before you ever disclose it. But the US gives you a leeway. It was 1 year from the first public disclosure or first offer for sale that you need to file a patent application. But given how long it takes, I mean, to build a brand, you're investing all this money in hopes that your product becomes valuable, right? So
right.
it is an investment. And, one of the things I work with a lot of startups and people trying to start up their business. So I get it. They come to me and like, I have this much budget. And if you talk to attorneys, we can attorney you right out of your entire budget because there are things that need to be done. But we have to pick and choose what you invest your money in, especially in a startup stage, because what's the point of having the best legal protection in the world if you have no product to sell because you can't get it to market?
Right, because you spend it all on the attorneys.
That's right. I'm telling you. I mean, they will lure you out of your entire budget.
Mm,
But just be careful. Just go into it. I mean, sometimes you're gonna have to pick and choose. You're gonna have to take risk. It is risky starting a business, and there are things you have to do, and there's things that you can possibly put off.
got it. Got it. The life of the entrepreneur, balancing what's important. But you
I know
mentioned,
that I know that attorneys have a bad reputation. So I just tell people I'm a lawyer. I'm an engineer with a law degree. So that's
there
what.
you go,
Yeah.
soften the blow a little bit. So,
Right.
well, but I mean, I've learned in the legal world, it's like anything else. There's quality attorneys where you're going to get what you paid for and it's good. And then, like anything, it's the 80-20 rule.
Yep.
There's a lot of them that they may not be bad, but they're not cream of the crop. And you may
Right.
not be satisfied with the results. So, but I think that's any field, right? If it wasn't, we wouldn't go seek the best doctors, the best auto mechanic, the best, fitness center, whatever, right? So
Yeah.
you
Well,
mentioned
Mike.
about the cease and desist thing. I just wanted to ask you about that because I was curious because you said that happens somewhat frequently that people are like, I got a cease and desist. Someone doesn't like my name. What do I do? Like, walk us through briefly, like, what would that look like and what should people do?
Well, I mean, it's one of two things. I mean, it's so first off, it's the United States, right? Everyone has a God-given right to sue. So that's
There's a lot of
that's
truth to
kind of where,
that.
yeah. So when you get the cease and desist letter, generally we look at it and we say, hey, you either have a good case or you have a bad case. And then even if you have a good case, do you really want to fight this? You could spend thousands, tens of thousands, maybe even $100,000 fighting this, or you can just spend that money on rebranding. I mean, it's kind of the, the heavy talk. Like, I know you love your name. I know this is what you want, but, you know, there's a reason why even attorneys need attorneys because emotional decisions sometimes don't get you where you should be.
So you're dealing with a lot of the emotional component.
Sometimes, I mean, you love your name. I mean, this is your business, right? I mean, your business is your baby. Your inventions are your babies. You know, when I tell people with patents, I'm like, stop showing your baby on the internet. Stop showing your invention. Let's get it filed, then you can show everyone, but don't do it prematurely. And you with your business. I mean, this is what you put your, blood, sweat, and tears into. And your name means something to you. Generally, that's why you put it there. You built up a brand name, you got a reputation in the community. And now someone from across the, US, someone you've never heard of, never seen of, is telling you that, you need to stop using your name. It can hit you like a ton of bricks.
Wow. Wow. But that's a great point. Instead of spending insane amounts of money on legal, if you rebrand, might be a better use of funds. But also when you rebrand, it's an opportunity to almost like a reintroduction to the market to almost expand yourself.
Right. I mean, you definitely can do that. And also, when we start talking about rebranding, with trademarks, we use what's called the intent to use application. And it's basically a pre-approval process that the patent office has. So what I tell them is like, look, time is of the essence. It's going to take them at least 7 months to even look at this. So what we do is we file like 3 or 4 applications to see which ones, hopefully they all get through. But if say only 2 out of 3 get through, then you can pick from those.
So what does it cost then to if you want to go get a patent, like what can somebody expect?
Well, that one's hard because, with patents, you always have. So I break it up in 3 phases. First phase is the prior art search phase, out the door, 1,100 to 1,600. Generally, sometimes it can cost more in special situations. Then the application writing. I tell people it costs generally out the door to write and file the application between 5,500 and 8,500. I've had some that cost less. I've had some that cost more. And those are different stages. So it's not including the first stage. Then you move into what I call the prosecution phase. And that's when you argue with the office. That one's really hard to give you an estimate on because it's game theory at that point. It depends on what they do, what art they use, and then what we decide to do in response to that, determines the amount of time that I have to spend on it. And then hopefully, sometimes the examiner will give you like, hey, if you do XYZ, I'll allow it. But if you do XYZ, your patent's not really worth anything at that point. So, they want to narrow it down. You want it as broad as possible, and that's where the conflict comes in. So that's why we try to negotiate. That's why we have interviews, we have discussions, we have proposed amendments, and but all that stuff takes time. And I generally say that substantive response with arguments, claim amendments, you're generally looking, a good middle median would be about $2,500 per response.
Per response.
Yeah. Well, hopefully what happens is your first response is kind of your big response, and then you narrow down the issues if you have to do a second response.
Gotcha. So adding all that up, 15, 20 grand, but it could vary wildly depending on what it is you're trying to do.
Correct. Obviously simple, inventions that are simpler, they don't cost as much, those kind of things.
So to your point about those inventions, what do you tell these founders with the inventions? You kind of alluded to it earlier, get the patent before you go on the internet, but if the patent's going to take a while, practically speaking, are they just not selling their invention? They just kind of keep it, or just sell it local home front, just don't tell the whole world yet, kind of thing?
Yes. No, once we file the patent application, go out and try to make money off of it. Because the patent
Okay.
path is that die is cast. But if you have a good idea that can make money, I mean, look around your home. Most of that stuff doesn't have a patent on it, and someone's making money off of it. So, I
Okay.
say a patent is a great thing to have, but it's not the end all be all. First thing I tell clients when they call is, or prospective clients, you don't need a patent to make money. Like we said, look around your home. Tons of stuff, none of it. And
Hmm.
generally, in and of itself, a patent will not make you money. A lot of people think that they're going to get a patent and then they're going to approach a big company and say, "Hey, you love my idea so much, you're going to pay me to go out there and see if there's a market for it." That's not the way it generally happens. I'm not saying it doesn't happen, but it's not how it generally happens. What generally happens is you need to go out there and show the marketability or proof of concept of your product, and then they want to buy into your company or buy your company. And the fact that you have a patent covering something that's making money makes it even more attractive. It makes it more attractive for investment because at least their investment is somewhat covered. And if someone wants to buy it, hey, they own the whole thing. You know, I don't watch Shark Tank, but I've watched it enough to say, hey, this is what people want to see. Proof of concept. Do you have any intellectual property? How much money have you made?
Love it. Love it. So, with your firm, you've been doing this for a long time. Is it like your firm has it grown over the years, or because it's niche, does it stay smaller and it just does what it does like a well-oiled machine? What does that look like? And I speak that because like, yeah, I'm in real estate, so I've seen real estate firms that they stay lean and mean, so to speak, and then some of these that get really big, but really the service isn't any better. Oftentimes it's less, quite honestly, than the small firms. No offense, but like what does that look like in your world?
Well, for me, like I've made a conscious decision to stay small. I don't want to increase it. So when you deal with someone, you deal with me. The way I kind of look at it, once you have one employee, you might as well have five because the headache that you're going to get, you do that. So I am a solo firm. I take care of all my business. It has allowed me the flexibility to, you know, I was always the dad that was, at the games and stuff like that. And,
Mm,
now that my kid has graduated, I may look to expand, but I basically have made a great living doing what I've done, and it's afforded me all that I could ask for.
wonderful, wonderful. What's one of the biggest challenges you've had to overcome in the process that's really helped you grow the most?
Well, that would be. I mean, it's just organization skills. I mean, you do this, rely on the technology. I kind of fought it for a while. I was like, I'm not going to pay for that. I could do this myself. I can put things on a calendar. Don't do that. Get all
Yeah.
the automated tools that can make your life easier and do it. It's going to save you in the long run.
Love it. So at the end of the day, innovation, it's about people with ideas. And for most people, when they have an idea in their mind, it's a big idea. And sometimes it is a big idea, right? I mean, you just never know. What's some encouragement you give to entrepreneurs who might feel their ideas too small or maybe even too risky to protect?
Hmm. Well, I mean, there is sometimes things that are just not worth protecting. But generally, the smaller patents don't cost as much. But it goes back to people ask me, when should I call a patent attorney? Like, how do I know if I possibly have something that's a invention? And I'm like, did you solve a problem?
Mm,
Now, if other people have this problem, they're generally willing to pay people to solve it for them. So that's kind of, you know your industry, you have to know what you're doing, you have to know your background. And is this something that would be valuable that people would be willing to pay money for? Now, we have to have honest, frank conversations because sometimes, like I was mentioning, your patent or your invention is your baby, and no one's going to tell you that you have an ugly baby, right? So
fair.
you just don't, yeah. So sometimes you have to sit down and tell them, like, look, I mean, I don't do that because it's a business decision. You might have to go out there and seek other business, entities or, there's a company that I work with, and when you come in and you're saying, "Hey, I don't know how to market this, I don't know how to do this," we work with them and they're able to put together a business plan, put it together for you. This guy was an MBA student, but he also puts it in like terminology that a non-MBA person can understand. And it kind of lays out like what you can expect. Do you think there's going to be income? Do you think there's not? So there are services that are related that I can help provide because you don't know the marketability. I mean, you may or may not, but a lot of people are doing this on faith, but fortunes have been made that way.
Business is all a bit of an act of faith, isn't it? Very
Yes.
much. Yes, yes. Wonderful. Well, Austin, this has been very fascinating. I appreciate you taking the time to share. It's just very, again, it's a world we don't really think about a lot of times. And for some entrepreneurs, unfortunately, the time they think about it is too late, as I'm sure you've seen more than a few times, I would imagine.
Yes.
But it sounds like, there's some things to think about. Explore the trademark thing at a bare minimum. And then if what you're doing is worthy of a patent, then they need to come see you, it sounds like, right? And to help them out. So
Right.
wonderful. Well, thank you for taking the time to share today. Again, just very insightful. And to our listeners, if you want to connect with Austin, we'll have his contact information below. Sounds like he might be looking to grow, so I'd reach out to him now before he becomes, the megastar. I don't know, but we'll have his contact information below. Clearly, a wealth of information and knowledge and experience. And what I love is Austin is you've seen both sides of it, both
Yes.
from the patent office side and from the person fighting for the entrepreneur side. That's a massive value add. So I want to thank you again for being on today. Can you leave us with a final word?
Yes. So if we're talking about patents, disclosure kills patents. Keep it under wraps. If you feel the need to talk to somebody, talk to a patent attorney. It's confidential. It's considered not disclosing. Get it off your chest. Makes you feel better. And then don't tell anybody else.
Good to know. Good to know. All right. Well, Austin, thank you again for being on today. Super fascinating, and I look forward to continuing the conversation.
Thanks a lot, Frank. I enjoyed being on.